I don't know if it's safe to talk.
Yeah, we'll get started in just a minute, Dave. We're just letting
Okay,
folks in.
I'll stay muted then. No problem.
All right, good afternoon, everyone. Thank you for attending today's webinar on surrendering firearms and saving lives. I'm Brooke Meyer. I'm the director of the Institute for Coordinated Community Response, and we'll go ahead and get started. A few housekeeping items before we begin. We encourage you to use the Q&A box at the bottom of your screen to ask questions throughout the presentation. And the presenters will also share some other interactive ways to participate, so be sure to keep an eye out for that. If you'd like to make comments or interact with the speakers and fellow attendees throughout the presentation, you can use the chat box for that, and be sure to select all panelists and attendees at the bottom of your chat box so that everyone can see what you've written. If you have any technical difficulties, in that instance, you can select all panelists option instead, and ICCR staff will assist. Let's give a little bit of background on the Institute for Coordinated Community Response. I think I see some new and familiar faces on with us today. Created in 2018 as a program of the Conference on Crimes Against Women, ICCR is a training and technical assistance program that works with rural communities to improve their systemic response to domestic violence. We work with teams made up of law enforcement officers, prosecutors, and advocates from rural Texas counties each year and take a deep dive into current criminal legal response and begin building the scaffolding for a sustainable CCR to domestic violence. In addition, we host regular trainings like this one, both virtually and in person, to ensure that rural communities across the state and the US have access to the most relevant, cutting-edge training on domestic violence dynamics and collaborative solutions. And while our program is geared towards rural needs through webinars like this one, we're also able to train practitioners from all over big and small communities who are committed to eradicating domestic violence. So thank you for your dedication to improving your own community's DV response and for being with us today. You can learn more about ICCR on our website, instituteccr.org, and I encourage you to sign up for our monthly newsletter to stay in the loop about all of the great training we provide throughout the year. And we do have several trainings coming up this fall. To start with our upcoming webinars, you can see those on the screen. We have 2 webinars in November, the first on confidentiality and privilege, the second on conducting focus groups with community experts and system practitioners. We also have our bi-monthly Rural Texas Advocates Call coming up again on November 17th. So if you are an advocate that serves any survivors anywhere in rural Texas, we would love for you to join us for that. We also have many in-person trainings coming up. We go out to our ICCR counties once a quarter. And so this is our second second round of in-person trainings there. So I will not list everything that's on the screen, but if you see a town that's close to you up on the screen now, visit our website, instituteccr.org/upcoming-events to learn more about that particular training and register to join us in person. And now I'd like to introduce our presenters for today's webinar. Julie Germann is the founder of Finding the Right LLC, where she provides training and technical assistance to improve responses to sexual assault, domestic violence, and child abuse. Julie is a former prosecutor with over a decade of experience prosecuting cases of violence against women and children. She has worked with sexual assault and child abuse multidisciplinary teams and trains nationally. She provides best practice reviews and contributes to legislative advancements and policy manuals, such as the START Toolkit published by the National Sexual Violence Resource Center. David Keck is the director of the National Center on Domestic Violence and Firearms through the Battered Women's Justice Project. He was appointed as court commissioner for Winnebago County in 2006, a position he held until retirement in 2016. Dave was instrumental in forming firearm surrender protocols for the courts in Wisconsin. He has been director of the National Center since its inception in late 2016. He provides training and technical assistance on various topics surrounding domestic violence and firearms. Julie and Dave, thanks for being with us, and please take it away.
Thank you.
Thank you, Brooke, and welcome to everybody. We're excited that you're here with us today. And as Brooke mentioned, we really want this to be helpful and informative. So as you have questions, please put them in the chat box. We'll have opportunity for questions at the end as well, but we'd be happy to answer any questions that you have as we move through today.
Thank you, Julie. This project was funded by the Office on Violence Against Women, and the disclaimer indicates that the department doesn't necessarily take any view on the topics that we discuss. They are our opinions only. Next.
So I think it would be very helpful for us to know where you're from and what your current job title is, how you might be involved with firearm surrender. Are you in law enforcement? Are you a prosecutor? So we're going to use Mentimeter for this today. Some of you probably are familiar with it. If you either open another browser on your computer or go to your smartphone and go to menti.com, enter the code 91690907, it will give you the opportunity to answer this question, and we'll be able to look at that here. If you leave that browser open, we'll have a couple other questions. Otherwise, you can just simply enter the code each time that we use Menti. So let's see. We don't have anybody participating just yet. There we go. So this is good. We've got some folks who are already working in a coordinated community response, the coordinator, some policy manager, folks from Austin, Texas, Washington County, Texas, Hereford. Looks like we got a lot of Texas folks today for sure. Some prosecutors, a judge. That's fabulous, because you're going to hear later on how important it is to have the bench in support of firearm surrender. And some folks from outside of Texas too. I like to see that. Nebraska, Seattle.
Yeah.
Very good. So, and thank you for playing along with our Mentimeter. Now you get a sense of how it works actually. And I'm going to advance that to another question. So if you just keep your Mentimeter open actually, this is going to now ask you to let us know where your jurisdiction is at right now on surrender. And hopefully it just advanced to the next question for you. If not, you can enter that code again, 91690907. And what I'm curious to know now is just kind of where is your community at on the issue of firearm surrender? And I know that's broad. You could be doing surrender either pursuant to a protection order or pursuant to a conviction. But just generally letting us know if there's any surrender happening in your community, maybe just getting started, you've tried, hit some bumps in the road. That's what we're hoping to see, just where everybody's at today. I appreciate those of you who are participating. We got some folks who are not doing surrender at all currently, no interest in developing protocol in their community. Some are just getting started, hoping maybe that this webinar can move that along for you. And then we actually have a fair amount of people who have developed a protocol for surrender and are actively surrendering firearms. So for those of you who fit that category, definitely as we go through this today, if you don't have questions, but in fact have a tip or want to share with the rest of the people on the webinar how that worked for you, please use that chat box and chime in. That would be great information, I'm sure, for others to have. So once again, thank you for participating. We're going to go back to the standard PowerPoint now. And move on from there. So what we want you to know is that that saving lives through firearm surrender is really an obtainable goal. We're going to be talking a little bit today about the statistics and the evidence that really this truly is an evidence-based approach to saving lives, that there is good research out there now about the usefulness, the validity of doing surrender, and that it is in fact an effective way to reduce homicide. And we're going to try to go through today just briefly some of the legal, logistical, and practical considerations that you'll need to think about as you're developing your protocol, or frankly, if you've maybe hit a bump in the road in your protocol and you're trying to figure out how to move forward. So we're going to start with the statistics a little bit about how significant this problem is in the United States and what we know about the potential solution. So from the data from the Center for Disease Control from 2019, we know that gun homicide killed over 14,000 people that year, and gun suicide killed 23, almost 24,000 people in the United States. And we know, oh, go ahead, Dave.
And these numbers went up significantly in 2020. So.
Yeah, and we also know that the killings involving guns actually account for 3/4 of all homicides in the United States. And that this rate of gun homicide is about 25 times higher than any other global economic leader country in the world. Very often, what we think about, what we worry about, maybe prepare for, teach our kids for as they go out into the world is to be wary of strangers, right? We prepare them for an attack, either inside or outside our home that might be invaded by a stranger. But the reality when it comes to violence, particularly violence against women, is that most women are murdered by someone that they know. So again, we're looking at the data that came out of 2019, and for homicides in which the victim to offender relationship can be identified, 91% of the female victims are murdered by someone that they know. So while what we tend to fear is that stranger jumping out of the dark alley, the reality is those stranger murders are pretty rare when we're talking about women who are murdered by men. It's 10 times more likely that you'd be murdered by someone you know. And important to note that it's not just homicidal violence isn't really related just to married partners. But is very prevalent among dating relationships, and that in fact, they account for nearly half of all intimate partner homicides.
And that's, comparing, for example, the definition of what a domestic relationship might be, where there's maybe cohabitation, a child together, marriage. These are people that don't have those connections, and yet this still accounts for about half of the homicides. I think it's a significant number to keep in mind. The other thing about the statistics here, these numbers here, really is just like Julie already alluded to. A lot of firearms, sales are kind of driven sometimes by this image of defending your family or defending yourself by arming yourself with a firearm. We'll talk more about that in a few minutes, but the reality statistically is much different.
So this is just a quote from Senator Wellstone over the debate when 18 USC 922 was passed, which is the law that prohibits certain individuals from possessing guns. And it's so true. And again, we'll talk about the statistics a little bit, but all too often, the only difference between a battered woman and a dead woman is the presence of the gun. And what we know about that is that more than half of the women killed in the United States, 58% of them are killed with a gun. And just the presence, the mere presence of the gun in a home where there is a domestic violence situation makes it 5 times more likely that that woman will in fact be killed. Women in the US are 16 times more likely to be killed with a gun than women in other high-income countries. And this number is just staggering. In an average month, 57 American women are shot to death by an intimate partner.
And it's also, we need to note that firearm sales since COVID, maybe the last 18 months or so, have been at all-time highs. And we have real concerns about that as well, because accessibility of firearms is really what drives a lot of this, including the suicides and murder suicides, which we'll be talking about.
And Dave, that's a good point. And I think another thing to note is that we saw across our communities what has appeared to be also an increase in domestic violence since the pandemic began, particularly in communities that were locked down, but a decrease in reporting. So we're seeing more domestic violence and less victims reaching out for help right now.
Very true. And we've also noticed that an increase in the sort of the level of violence. I think most people have been shocked by that as well, that the type of behavior that we're seeing is just more severe than would be typical for a year like this.
Yeah. So not only are guns used to inflict injury and oftentimes death, but we know that they are also often an instrument of coercive control for individuals who are in a domestic violence relationship. Just having that gun in the home or using it, pulling it out during an argument, cleaning it during an argument, keeping it on the mantle or the top of the dresser, just somewhere where it's always visible, always that reminder of what kind of a threat it is definitely one of the ways that guns are used in coercive control. And again, the numbers here are just alarming, that 4.5 million women in the United States have been threatened with a gun by an intimate partner. And go ahead, Dave.
No, finish. Go ahead.
Oh, a third of the callers, when they looked at the calls made to the National Domestic Violence Hotline in 2018, a third of the callers reported having been threatened by the gun. And interestingly, when we look through that, we find that women who have been threatened with a gun suffer more symptoms of PTSD than others similarly situated individuals in domestic violence relationships.
That's what I was going to say. You got it. Thanks. Thank you.
So protective orders, we all know, are often sought out by women, particularly at the moment in time when they're trying to leave their domestic violence relationship. We also know that that time of trying to separate from the relationship is historically one of the most violent times, and the time that is most often ends in a homicide. So April Zioli is a researcher who looks into firearms and particularly firearm surrender. But she did some research into looking at why is it people are seeking protective orders, or what are they reporting in their protective orders when they are seeking that protection from the court. More than half of the individuals seeking that protection had suffered severe physical abuse. Nearly half of them had been physically injured. And, wide range there, 13 to 48% reported sexual violence, and over half reported being stalked prior to seeking their protective order.
It's important to keep in mind when someone does finally go to court and petition for a protection order, really that it's the kind of the last resort they've got, and that's not the first thing people think of.
Absolutely. The other data that we kind of wanted to know when we looked at is, what do we know about the respondents? So the people that the protective orders are being sought against, what do we know about them? Again, when we researched this, we found that the majority of them have criminal records, and actually pretty lengthy ones. The average criminal record is 13 complaints. So pretty lengthy records. More than half had criminal charges against the petitioner of the protection order in question, or of a former partner. 40 to 71% were known to the criminal justice system for having hurt the person, having a crime against the petitioner who was seeking the protection order. Again, quite a large range there, but a lot had threatened to kill or seriously harm the petitioner, and some had even threatened to kidnap children. So researchers over 35 years, this has been pretty consistent, have found that association between separation and intimate partner homicide. So we know that this is an incredibly dangerous time, and we know that this is the point at which victims may seek out a protective order from the court.
My point exactly. When somebody does come to court, that's when they need to be taken seriously. If they're turned away, or if they have any other bad experiences, there are people who may not come back to the court again. So it is important to keep in mind that this is a really kind of a important point in whatever the relationship is.
And that time of separation is not only when we see homicides rise, but we also see suicides or those murder-suicide connection cases rise. So between 1,000 and 1,500 deaths per year are actually the result of a murder-suicide. Most of them, 90%, involve a firearm, and 65%, so well more than half of them involve an intimate partner. And Dave, didn't you have an experience like this in a case of yours involving a protective order?
Yeah, I did. It's how I really got started on all of this many years ago when I started out as a court commissioner. Court commissioner is like a magistrate or referee in some states. One of the things that I did was protection orders, but I also did family court cases, and I had a young couple come in front of me for a divorce. They were both unrepresented. They had some small kids, and I kind of just did the temporary order and all of that and sent them on their way. A couple of weeks later, they were back in front of me because of domestic violence, and the wife was seeking a protection order, which I did also grant. And then just a couple of weeks after that, I ended up having to close both those files because husband had shot himself. And when I first heard that, I kind of looked at my staff and said, "How did he do that?" I ordered him to surrender his guns. But yeah, I knew the answer as soon as I asked it, because I didn't follow through. I just did the standard thing that everybody had done before. It's just a hand him a form saying you can't have a gun. There was no follow-up. But that's really for me, that was a hard lesson, and it's something that's motivated me right away when I had the opportunity to put together a surrender protocol. I was already really ready to do it because I just didn't want that to happen again.
So kind of like the ripple on the, oh, am I having a lot of feedback?
Julie, really quickly, there's a question that came in.
Oh, okay, let's do that.
It's a very interesting one. Does the likelihood of gun homicide go up with every time a victim tries to leave? Since victims typically attempt to leave more than once, Does lethality rise with each attempt at different rates? I don't know the answer, but I don't know. I don't know if I've ever seen any statistic on that.
I haven't either, but I think it is a very interesting question. And, you know, certainly when you look at lethality factors, we know that there are certain things that raise the chance of lethality. Leaving is one, of course. A partner who's used strangulation in the past is another. Having a gun present in the home is another. So that would be an interesting factor to look into.
Yeah,
But
what comes to mind for me is you know, clients I've had who have been victims of some, you know, physical violence, at least. How often they would say, you know, we were together for years, and we had arguments, you know, here and there. I didn't think this time the argument was going to lead to that, and the physical assault. And so that's kind of what bothers me about this is, you know, you may try to get away a couple times, you may end up coming back or something, but you never know when somebody's going to act impulsively. And with firearms, it's, you know, I don't know if you can predict that. I think it's just something to think about.
yeah, and so the other thing I know is that Jackie Campbell, who is kind of one of the premier researchers in developing the lethality assessments that probably many of your communities use. They're currently replicating that study and looking. Texas is actually one of the states that's being studied in the new research that Jackie's doing. And I know that they are looking at a lot of additional factors to determine what are the lethality factors that we should be considering in these cases. So hopefully as we get, you know, the newest round of research in using lethality assessments, there might be some more information on that.
Yeah, hopefully. I just wouldn't want to speculate on a question like that, whether it gets worse or not. I just don't feel like I could answer that.
So like this picture with a ripple on the water, you know, for a long time, I think hopefully society has really moved on beyond this idea that, you know, domestic violence is a problem that you keep quiet and it's between just that family or just those two people. But what we're really starting to see is what the impact of domestic violence, particularly including firearms, is on our larger community. And one of the areas where we really see that, and we've started to see the statistics on that, is mass shootings. So men who eventually go on to commit large-scale acts of terror often have started with violence in their home. So this is Cedric Ford. In February of 2016, Cedric Ford shot 17 people at his Kansas workplace. And this was about 90 minutes after being served with a restraining order that had been sought by his ex-girlfriend, who alleged that he'd been physically abusive to her. Of those 17 people shot at his workplace, 3 of them died. And this one's probably familiar to a lot of people who are joining us from Texas. In November of 2017, Devin Patrick Kelly shot 46 people, killing 26 of them at the First Baptist Church in Sutherland Springs, Texas. Interestingly enough, Mr. Kelly also had a violent past. He'd assaulted his wife and stepson while he'd been stationed at Holloman Air Force Base in New Mexico, fracturing the baby's skull, hitting, kicking, and strangling his wife. He was subsequently convicted of domestic violence and released early from the Air Force. He was not, however, disarmed at that time for his violent convictions. This individual is Jared Ramos. In June of 2018, Jared Ramos killed 5 and injured 2 at the Capitol Gazette in Annapolis. After this, it was learned that he too had a long history of abusive behavior toward women, including harassing and stalking different women. So we can see we could go on and on and on through individuals who've been known to have committed a mass shooting and find their connection to domestic violence. And interestingly, a Bloomberg report from 2020 examined 749 mass shootings that have occurred in the past 6 years. And 60% of those involved in the shootings were men who had histories of domestic violence, or the actual mass shooting involved domestic violence, killing a partner, and others had a domestic violence based motive. But even more interestingly, out of this study, those incidents with mass shootings, the more deaths that occur, the higher that gets, the higher the correlation to domestic violence climbs. So when you get to a mass shootings that ended in 6 or more deaths, that correlation goes up to 70% of those responsible were also perpetrators of domestic violence.
Yeah, I mean, statistically, there really does appear to be a connection there. And one of the things that people sometimes ask about this is, what's the link? What is the link between domestic violence and mass shootings? And from my perspective, that's kind of the wrong question to ask. I think that really what we should be looking at is what's the difference? What's the difference when somebody decides they want to take the lives of their own children, their wife, other family members, and they want to extend that to more people and then out into the public. It's really kind of hard sometimes to determine where it changes over from domestic violence to mass shootings. And I don't think the distinction is really that important. I think it's statistically, it appears to be very similar behavior, or at least have a similar explanation if there is one.
Additionally, what we know is that responding to domestic violence calls is always very dangerous for law enforcement. And in particular, of course, it's more dangerous if the individual that they're responding to is armed. So last year in 2020, there were 264 law enforcement officer fatalities in the United States. 48 of them were firearm related. Unfortunately, Texas had the highest number of law enforcement fatalities in the last 2 years. And we know that looking back a little bit, 2015 to 2016, 41% of fatal calls for service were domestic violence related. So we know that it's not just, it's the individual involved in that relationship who's at danger. It's anyone who could be affected by someone doing a mass shooting, but we know definitely our law enforcement officers are often killed in the line of duty responding to help victims in these situations. Finally, we talk about gun violence being a public health issue. And I think this is important. Some of you who are on this call today may say, gosh, we really want to do something, or I'm interested in doing something, but it's difficult to get the powers that be on board, to get my community on board with doing this. And one way, and I saw someone was on here from Seattle, one of the ways that Seattle was effective in getting, King County, Washington was effective in getting their surrender program going was in part by getting public health behind them and saying that this is actually a public health issue, gun violence. And just it's another agency, it's another level of support. So something to think about as you're looking for those champions in your community who might help you get this started. More and more public health is a good avenue to seek out that support. So we're going to talk a little bit now about keeping weapons away from abusers. We're going to look at the law and kind of the steps that you need to develop a protocol to take weapons away from abusers. So initially, we're talking about federal law. Federal law prohibits the possession of a firearm by those convicted of a domestic violence misdemeanor or those who are subject to a protective order, as long as it's a final order, meaning there's been a hearing, and that order protects an intimate partner of the abuser or the child of the abuser, intimate partner. The tricky thing about the federal law a little bit is how intimate partner is defined. And if you remember earlier, we said over half of the domestic violence homicides involve dating partners. Well, this specifically precludes dating partners, this definition of intimate partner, if they are not living together or have lived together in the past. If they are merely dating, they're precluded from this definition.
And it's possible if VAWA gets taken up and moves through the Senate, that this is one of the potential areas that may be modified by that.
Right, and it has been the holdup to passing VAWA in recent years is because they did intend to what they call the boyfriend loophole. When you hear about closing the boyfriend loophole, this is what they're talking about, the fact that dating partners is excluded from the definition of intimate partner in the federal law, and they wanted to close that up. Now, I will tell you, many programs who do firearm surrender rely solely on this law, the Lautenberg Amendment, because their states do not have a mirroring law that either matches it or goes further than the federal law. And so there are many states that are putting into place a surrender protocol based on enforcing this federal law. So if you are from a state that doesn't have its own mirroring law, precluding or providing for prohibition of firearms in a protective order situation, you can rely on this federal law as your basis.
And relying on protection orders, I think, is a good place to start, because you don't have some of the issues that sometimes come up with the other prohibitor, the misdemeanor crime of domestic violence, because that definition sometimes is a little bit trickier. If as long as you fit the definition you've got here for the relationship, then you should be, like Julie says, you should be able to remove firearms. It prohibits the possession or purchase of firearms, and in some communities do rely on that only.
So there are state laws that, oh, sorry, I'm sorry about the echo. I'm not sure why that's happening. So there are state laws that do prohibit firearms or ammunition for those who've been convicted of either gun-related or violent misdemeanors. And the 27 states are listed there. And this is one, again, where when we talk about evidence-based, what we know is that when they implement this law based on violent misdemeanors, so this is one where they don't care about the relationship between the two parties. We don't care what your relationship was. If it's a violent misdemeanor, you can't have a firearm. That actually reduced intimate partner homicide by 23% and firearm intimate partner homicide by 25%. This, from the research, is actually one of the most effective ways to reduce homicide, is by basing it on the crime committed and without concern for the relationship of the parties. And of course, that's good argument for why we need to close the boyfriend loophole, because in the situation where you just look at the nature of the crime, we see the best reduction in homicides.
I think that's probably all true. That the one thought is maybe that you're including a larger group of people when you take in all the violent misdemeanors, but at the same time, you're not really holding yourself back by kind of have that restrictive language that I think probably prevents a lot of firearm prohibitions from going into place, because it's too difficult to determine that relationship if it's not documented by the state where the conviction takes place.
Mhm. When we look at state laws with protection orders, I don't have them all listed here, but it is about 2/3 of the states that prohibit firearm possession by abusers who are subject to a final domestic violence protection orders. Only about half of the states authorize either, provide the court the may authority or require a court shall authority to require the abuser to surrender a firearm. So that's where we start to see some disjunction, right? So we have lots of states saying you're prohibited from possessing, but we have fewer states saying, hey, we're actually going to take your gun when you can't have it. So although lots of individuals are probably being told at the point that a protection order goes in place that they should not or cannot own a firearm, that they could maybe even be charged with a future crime, most places aren't taking that proactive step to actually take the firearms that they already have.
And it sends something of a mixed message, because you've got the federal law that says you can't buy one, you can't have it. But then if the court says or doesn't say anything about and you have to relinquish it, it can be a confusing message to defendants and respondents. They want to know, do I have to give up my gun, and or do I get to keep my gun? And I don't think the court can honestly say or legally say, yes, you can keep your gun, because it's a federal violation, if not a state violation. So this like you said, this connect between the two does leave some ambiguity, and it also is, I think, just straight out confusing sometimes about what someone's obligations are under their conflicting laws.
When we look at ex parte orders, or the temporary orders, we have 16 states that allow for a court to order firearms surrender or seizure at the ex parte stage. So this goes beyond the Lautenberg Amendment, beyond the federal law, and allows courts, even before there's been a full hearing on the merits of the protection order, to order surrender of firearms. This is another one of those sort of interesting evidentiary-based practices, because when we look at the data from that, seizing guns at the ex parte stage was associated with a pretty good reduction, 12% reduction in intimate partner homicides and 16% reduction in firearm intimate partner homicides. And again, this one makes pretty good sense when you think about it. We talked about how that is the most dangerous time. And so if we can get those firearms in that early stage, before we've set out for a hearing, we're more likely to prevent homicidal violence. So in communities where domestic violence protection orders require firearm removal, it is certainly associated with a reduction in homicide. So this is when they looked at communities that require firearm removal after a final hearing. So not just ex parte, but ex parte or a final hearing. And you can see that those initials stand for total intimate partner homicide, intimate partner firearm homicide. Both saw a 9% reduction in those communities. Female intimate partner homicide, an 11% reduction, and female intimate partner firearm homicide, a 12% reduction. So again, this is from the Annals of Internal Medicine, and this is April Zioli's research as well. But they did an analysis of data from 45 states over the course of 34 years. And they were looking at states who had gun restrictions covering emergency restraining orders in domestic violence cases. And they had a 14% fewer firearm related intimate partner murders. And here's what's interesting about this research that April did, is that very often you will hear people say there will be, what we call the substitution effect. If you take their guns, if somebody really wants to kill another person, they're going to find another way. They're going to use a knife. They're going to use strangulation. They're going to do something else. But what we see in these studies is that there was no substitution effect, right? We didn't see an increase in intimate partner homicide of other means. We saw a decrease of intimate partner homicide across the board, as well as a decrease in firearm intimate partner homicide. That's interesting. It takes away that argument that they'll find someone else. And it really speaks to kind of the immediacy of being able to grab a gun in the heat of the moment versus not being able to grab a gun, and how that plays out in our crime statistics.
Yeah, I think that's, I think that's the sort of the significant thing there. There's really a kind of a suggestion that there's a connection here between the accessibility to firearms and the homicidal behavior. I think there's even a parallel here probably to suicides, because my understanding is suicides have a sort of a similar rate when there's a firearm available. It's sort of the impulsivity plus the availability of, and it's a deadly means too. So, it's really a bad combination.
So all of this makes sense and it sounds pretty good. So then the question kind of becomes, why aren't we doing it? If it appears from the data that surrender laws work, if we know that communities that don't have a surrender law on the books are successfully enforcing the federal prohibition, why is it that this isn't moving forward? Why aren't our communities doing this in greater numbers? And there are a few reasons for that. As we mentioned, the federal law is a prohibition against owning or possessing guns, but it doesn't outline a procedure for the gun surrender of the guns you already own. Additionally, lots of state laws also fail to outline that procedure. They may also have a prohibition that either mirrors the Lautenberg Amendment or goes further, but they failed to kind of create that procedure or that statutory authority about surrender, leaving states and communities to have to develop their own protocol. Often there's a lack of coordination. This kind of effort for surrender really does take, basically, for those of you who are already working in a coordinated community response, that's really what it takes. And that's why this is such an interesting project for an ICCR group to take on. Because you've already worked out how to work in a coordinated way between law enforcement, prosecution, advocacy. The one person who might not be part of your CCR that is crucial to a successful surrender protocol is getting the judicial system involved. But if you already have a highly functioning team working well together to address domestic violence in your community, that lack of coordination really shouldn't be a holding back factor for you. You should be able to move forward. The other reason that they're not enforced or that we hear frequently is a lack of resources, just time, money, staff. We hear about concerns about storage of firearms. So those are some of the reasons why they're not currently being enforced.
And really, a lot of times it's just a matter of priorities. Places that we've heard about, like Seattle, King County, I think Harris County, Texas is an example of this as well, that it's somebody who just decides that they're going to make it a priority, to do this because it has the potential to save lives. I think that's a lot of times what you need to really drive something like this forward.
And Dave just mentioned a couple of communities. We're going to talk about a couple of them here, but if you do go out to our website, which is preventdvgunviolence.org, you can see we have what are called community spotlights. If you click on that at the top, and you can see Dallas County, Texas was highlighted on there. you can read about different communities and how they took on firearm surrender. The interesting thing about these communities is they're all of different sizes. They're in different states. Some of them took on firearm surrender for protection orders. Some started in the criminal system with convictions. So they've all gone about it differently. And their systems all look kind of differently, how they surrender it, but they've all been very successful despite doing it differently. And so you have the opportunity to go out there and read about those. One we did want to highlight for you is Houston, Texas, which is Harris County, Texas. So they're quite a good success story right here in the state of Texas. They started a pilot program they called their Safe Surrender program in the 280th Family Court. And that began back in December of 2018. And then by October of 2019, having had good success in surrendering firearms in protective order cases, the Harris County Commissioners Court unanimously voted to expand that surrender to cover all 22 felony courts in the county. Now, unfortunately, I think that grant of money and that expansion hit just about the same time as our pandemic. So I don't know, maybe if somebody's on the call from Harris, maybe they have an update for us. But so I don't know how they're doing it, rolling it out to the felony courts just yet. But they are having good success in their program that they developed. So another kind of interesting success story comes to us out of Georgia, DeKalb County, Georgia, which is about 10% of the city of Atlanta is encompassed in DeKalb County. And they went about it in a completely different way in that their firearm surrender program is actually run by state court probation department. So they started their program focusing on anyone convicted of a misdemeanor domestic violence, giving them 24 hours to surrender their gun to the probation office after the point at which they're convicted. So they have been enforcing the federal prohibition because, again, Georgia has no mirroring state law successfully through their probation department since 2011. So we want to talk a little bit about how you go about implementing a surrender protocol. And we're going to focus today on how you would do that in a protection order case. It would be slightly different in a conviction scenario, although some of the steps that you need would be essentially the same. But we'll go through it today for protection order case. So we'll go through each of these individually, but just to give you an idea, there really are just a few elements that are required for an effective surrender policy. The first is going to be collecting the firearm information. How are you going to get the information about firearms? The second is the court order, what needs to be in there. How is it going to be communicated to the respondent, those kinds of things. Service of that order, understanding responsibilities. Again, how are we going to communicate to respondents what their obligations are under the surrender protocol that you developed? What is the surrender process going to look like? You know, to whom can they surrender, when, how quickly does it have to be done, and how does the court find out that it was in fact done? And then what kind of mechanism are you going to use to monitor compliance? Because it's not enough just to order someone to turn over their firearms. We have to have some sort of system in place to follow up and make sure that it's actually done.
And we'll talk about the reasons why, but in lots of ways, these are most effectively put together when there's like not only court involvement, but some of these steps kind of starting with the court for different reasons. One of which is that it reduces the amount of work time that would be otherwise required to have law enforcement, for example, going out and monitoring whether somebody has become prohibited or not. making sure they've done their, turned the firearms in. The way we were going to talk about it is really having the court do it and then put the burden on the respondent or the defendant all the way through the system to comply and to prove compliance.
So we'll start with talking about obtaining firearm information, and then, keeping in mind again that we're talking about particularly a protection order case. And so having advocates utilize a questionnaire with petitioners about firearm access and possession, or that the petitions or supporting affidavits that the petitioner would use to request the protection order leaves space or has an area on it for petitioners to provide information about firearms. Having a way for petitioners to ask, right, or request that discretionary relief from the court regarding the prohibition of firearms and the surrender of firearms. And while we're talking about getting that information from the petitioner, we do like to remind people that really in the instance of domestic violence, those individuals who are victims and survivors know best how to keep themselves safe. And so the petitioner's response about firearms should always be voluntary. If a petitioner feels strongly that that is the step too far, right, to tell the court about their partner's guns would be the step too far, the step that might get her hurt or killed, then we don't want to be in the business of making her do that, but that it should be voluntary. Who it should not be voluntary for would be the respondent. So asking the respondent, either having him fill out a form, asking him in court and documenting that answer. There are different ways to go about getting that information.
And really, yeah, it's
go
that
ahead, Dave.
It should be the respondent's burden, right? I mean, it's his problem. He shouldn't shift that burden to somebody else to prove what he did or didn't do. If he's got firearms, he's subject to prosecution. So he's the one who really should fix the problem. It's the best place to put it. It takes it away from them, takes the burden off of the petitioner, where we don't want it for various reasons.
Right. And I've put on the screen now a couple of examples. You can see one comes from the state of Wisconsin, and it's the petitioner's statement. So this would be the form, and you note right on there, it says this is optional, but it's included in the packet, allowing the petitioner to make a statement about respondents' firearms, if they know the make, model, or where they're located. And then on the other side of the screen, you'll see this comes out of Dade County, Florida. And this is the form that they would require a respondent to fill out. And you can see it's a sworn statement of possession of firearms done in the courtroom under penalty of perjury about whether or not they own firearms. And if they do, again, all the specifics you can get about make and model. And so these are two forms, and that's one thing we haven't mentioned to you yet, but in part of our work at the Resource Center, we visit the communities that are doing firearm surrender and doing it well, and we collect their protocol, we collect their forms. So when you reach out to our center saying we want to develop something, or we're trying to, we need a form for firearm surrender, we have lots of options to share with you. So communities shouldn't feel like they're reinventing the wheel to do firearm surrender. If you reach out to us, we can certainly give you something that you might just be able to adapt for your community's use, and it will save you the time and energy of developing your own. So next we want to talk about the court order. When the court orders surrender, it needs to be, obviously very clear and specific terms about the timeline, the firearms, which firearms we're talking about, the location, if that's known, and providing the respondent or defendants with instruction sheets, something they can take from the courtroom that lets them know this, because we know not everybody in court is comprehending or taking all that information in, but we want them to know their deadline to surrender, where and how to surrender, what type of proof is going to be required? Will they get a receipt for their surrender, and do they have to return that to the court? Does law enforcement return the receipt to the court? So just so everyone's clear on what's required and what will be their consequence if they fail to comply with this court order.
And this is always where I kind of talk a little bit about due process and due process and what sort of notice and opportunity do people have here, and what's the the big picture. In some ways, offering that respondent that every opportunity to comply with a clear order, the more you can help that person to actually do that, surrender those guns in a way that's legal and safe, the more chance you give him, the better chance you have of getting him to comply, which results in hopefully a less dangerous situation for the petitioner. At the same time, the more opportunity you give him, the less sort of excuse he has for not complying. So that goes full circle, and you can also, because of that, you can also impose greater consequences if somebody is not following what the order that they should. So due process kind of goes in a full circle in this case.
So next we want to talk about service, and this is something that rightfully so, I think law enforcement brings up as a concern when they're serving an order on someone that says they have to surrender their weapons, whether or not that situation will turn volatile, and whether it will be even more dangerous. We know that the domestic violence situations are already dangerous for law enforcement. Keeping in mind that service in these cases is often a two-step process. So very often respondents will be served with that first temporary order, and then possibly even the same officer will be going back at a later time to serve the permanent order. So one community that we've worked with, or maybe it's more than one now, but has made a policy of that serving officer to sort of make a soft sell on that first contact on the temporary order and just inquire about firearms access position. That officer can make note, record that down, that response for future contact. Could just be, hey, just serving you with this order for my safety. I just need to know if you have guns. Especially if firearms aren't surrendered that day, because that information can be particularly useful to the court at a later time if we have a respondent who wants to swear to the court that they don't have any guns, but have previously told an officer at an initial contact or the first serving of that temporary order that they do in fact possess firearms. That can just be some useful information, could just be part of the protocol and standard for serving orders. So understanding responsibilities is important. For the defendant to know what it is they have to do to be in compliance, or the respondent to know what it is to be in compliance for their order to surrender. So some communities provide a letter at the time of service of the protection order. So that would be included with their final protection order. You have to surrender your firearms, and here's the detail for how you do it. I think we have somebody on the call from Seattle. And so King County has created a video for respondents that are ordered to surrender. And I think it's a very useful video. It's done in a very non-threatening manner, just explaining the situation. The whole nature of it feels very de-escalating to me. And so we're going to play it for you just as an example of something that you could show in the courtroom, or you could have up on your website to explain firearm surrender.
Hi, my name is Officer Hamlin. I want to help walk you through the process of surrendering your weapons based on the court order you received called an order to surrender weapons. It is important to know that this will not last forever. If you turn in your weapons and follow the court's order, and there are no other orders or convictions that say you cannot have firearms, your weapons will be returned to you as soon as the order expires. Now, I know that going to court can be hard and confusing. This is especially true when you may also be going through a tough time in your life. Our goal is to keep you and others safe while you're working through this. There are federal and state laws that say people who are restrained by certain protection orders can no longer have guns in their possession or control, or have a concealed pistol license, often called a CPL. If the police did not ask you for your firearms and CPL when you were served with the order, the law requires you to immediately turn in all of your firearms and your CPL to police. The law also says you cannot buy any guns, apply for another CPL, or have any gun in your possession or control while the protection order is in place. If you have guns or a CPL, you must immediately turn them in. So how do you do that? The order you received will tell you where you should turn your guns in. Now, when you turn your guns in, the police department or sheriff's office will give you a receipt that lists each firearm and CPL you turn in so that the court can make sure you've included all of them. If you don't turn in all of them, you will be in violation of the law. Now, some people have concerns about whether they'll ever get their firearms back or if the police will take good care of them. The law requires the police to store them so they can be returned to you. The order to surrender weapons will end when the protection order expires. At that time, you can go to the police agency where you turn them in and ask for them to be returned. They will be returned if there are no other orders or convictions that say you cannot have firearms. As far as safe storage is concerned, don't worry. The police take great care to make sure your property is stored safely. Now, this next step is also important. After you surrender your firearms, you need to give the court a copy of the police receipt and fill out a form showing the judge that you surrendered the guns immediately. This form is called proof of surrender and receipt. You have 5 days from the day that the judge signed the order to surrender weapons to file the form. If you don't provide that proof to court within 5 days, you could be charged with a crime. So what should you do if you don't have any firearms? First, it's important to understand that once you are served with the order, you may not give away, transfer, or sell your guns to someone else unless the court gives you permission to do so. And that person needs to come to the court so the judge can make sure they are allowed to have guns. If you gave, sold, or transferred your guns before the court issued the order, you'll need to bring proof of that to the court. You're still required to fill out a form swearing under penalty of perjury that you do not possess any firearms or concealed pistol license. This form is called a declaration of non-surrender. It must also be filed with the court within 5 days of the judge signing the court order. You must tell the complete truth on this form, or that also will be a violation of the law. You can turn in your forms by coming to the courthouse directly, by sending them to the court through the mail, or filing the documents electronically. But it is your responsibility to get the forms back to the court and to show the court that you obeyed the order. You may also have been ordered to attend a compliance review hearing. The date on this hearing is listed on the top right corner of the order to surrender weapons. The review hearing is often scheduled either several days to a couple weeks after the order to surrender weapons was signed by the judge. You are required to go to this hearing. If you do not go to this hearing, you may be charged with a crime or be found in contempt. In the review hearing, the judge will look at your court file to make sure you surrendered all of your guns or CPL immediately and filed the form showing you did it within 5 days.
And you signed a declaration of non-surrender?
Yes, ma'am.
And you're saying you don't have any weapons or firearms?
That's right.
Or if you do not have guns, that you filed the form swearing that you do not have any, or to provide proof if you sold or transferred them before the order was issued. We know this may be a very difficult time in your life. We want to make sure you and others stay safe until the situation improves. We also want to make sure you follow the law. Thank you for your time.
Julie, we've got one question, it looks like,
Sure.
about that video. How do they make sure the person surrendering the firearm has watched the video? I don't think they do. Do they? I don't think they know whether that person's done that, right?
As I understood it, I thought that it was shown when people appear for their protection order hearing. So I think it's just shown to everybody in the same way you sometimes show rights videos before the start of like a traffic cattle call. I think they had a protocol of just showing it to everyone in the court, and that way, whether you were ordered to surrender your firearms or not, you saw the video, because even people who say they don't have firearms still have a form that they're required to fill out. So I do believe they show it to everyone.
Yeah, and I think if you didn't see the video, I don't think that would excuse you from following the court's order. So I would think
No,
it would be in order.
right. And they also put all that same information in writing. We just know that, not everybody takes the time to go through forms carefully. And so I think this was just another option to try and make sure that everybody understands. And do they have it translated into other languages? That's a great question. And I think it would certainly be necessary in certain communities that that video would need to be either produced in multiple languages or translated.
Again, that's the same, this video is very good because I think it does, like my point about due process, it gives you a clear explanation of how to do it. But then if you don't do it and you had it explained to you clearly, there you don't have an excuse for not doing it. But this translation question is also another very good one. Again, by making sure that the respondent understands by translating it, maybe it's because it's a different language that person speaks. That again is another way of ensuring that there's safety or protection for the petitioner, because if the respondent doesn't understand what the order is, he's not going to be able to follow it.
Right. So when you talk about surrender process, again, communities do this different ways. Some require surrender only to law enforcement or a licensed firearms dealer. There are some, and you heard mention of that in the video we just watched, potentially an approved third party. So that we don't consider third party surrender to be best practices. And if a community does allow for it, you want to be really sure that that gun isn't getting back into the hands. I'm just going to give it to my buddy or my brother, and he's just going to turn around and give it right back to me. And so if you are a community that's considering third party surrender, having that third party come to court, have a criminal background check, making sure that they don't have any prohibitions on their own record from possessing firearms, and then also making sure that they hear from the judge that they are responsible for that firearm and the consequences that would flow from giving that back before they should. And so the policy on how you're going to contact law enforcement to surrender, that's got to be part of your surrender process protocol, right? We don't want people just walking into the courthouse with a gun or walking into the police station with a gun unannounced. And so we see this, we see people do this a lot of ways. Law enforcement has the individuals lock the guns in their trunk. They come into the police department unarmed. They're escorted back out by 2 officers to take the guns from the trunk. There are lots of ways that can be achieved, but you're going to have to think about that in your community, in your team that's working on this. How can we surrender guns safely? What's going to be our protocol? And then a receipt, both that you want to give a receipt to the respondent for their firearms, but we highly recommend that you take a digital photo of the firearms for records, the condition that it's in when you take it into custody. Certainly there's a lot of concerns raised, and it was brought up in that video as well, that maybe law enforcement isn't going to take care of the guns appropriately, or that they will be damaged by being in storage. So it's really good protection for law enforcement just to document in a photograph the condition of that gun when you take it into custody. So additionally, your protocol has to include how is the court going to be notified that surrender is done? So if law enforcement is issuing a receipt for the firearms, is it the respondent's responsibility to get that back to the court? Does law enforcement provide it back to the court? There's really not a wrong answer there. You just have to make sure that's part of your protocol and it's clear whose responsibility that is. You'll want to develop your protocol with regard to storage. What is the policy for maintenance of the stored firearms? And importantly, a lot of communities have found that if they didn't do it initially, they needed to later figure out what the policy was for destruction. So some individuals are permanently prohibited. For a protection order, it's just during the length of time of the protection order, but for a conviction, that individual is permanently prohibited. And so if that is the case, what is your policy for destruction of those firearms? Because I know law enforcement isn't interested in storing those indefinitely. And then finally, what is the protocol to return the firearms? So there has to be a protocol in place when the protection order has expired, that there is still another check on that individual's record to make sure no new prohibitor has arisen in that time frame before the firearm is returned to them. So compliance monitoring, this is kind of the sticky wicket in all of this. If there is no compliance mechanism and we're just on the honor system, frequently we don't have a lot of firearms turned in. So there has to be some system for following up or monitoring. In the video, you heard from Seattle King County that you might have to come back to court for a compliance review hearing. So some communities will set that hearing date on the day of the protective order hearing. When you're ordered to surrender your firearms, you're ordered to have a compliance hearing in 7 or 10 days or whatever fits within the window for having surrendered. Sometimes they set it up so that that hearing can be waived if in the interim they get the receipt proving that you did in fact surrender your firearms. But something that's on the court's docket so they have a way to follow through with compliance and monitoring that it's actually being done. Others do just a very form intensive process where the court clerk monitors whether or not the receipt has come back. And there isn't a hearing on the books, but maybe one is added when they don't get the form back, or they could use another option such as if they don't get the form back, a search warrant issues for the firearms in question, or that a contempt proceeding is started because that individual is now in contempt for not following the court order to surrender. And then the final mechanism would be potential new criminal charges.
All of those kind of require someone to take the initiative to make sure that they've monitored, to make sure that there's something wrong, so that they can start maybe a hearing or look for a search warrant or schedule something like that. That's why in a lot of ways it makes more sense to have the court just automatically do it, since the case is in front of the court and you got the file right there. Just schedule a hearing. Let the respondent do the legwork, the work to take it back off the calendar. Otherwise, it just remains on there, and most of those hearings, ultimately, that are not very long hearings, for one thing. But the other thing is that nobody else, the law enforcement and the court, don't have to do all the scheduling to do that. It's already put in place.
Mm-hmm. And but as you can see, this is why it's so crucial for those of you who have been working in a CCR that might just be made up of prosecution, law enforcement, advocacy, that to make this work, you are going to need some judicial support. You're going to need a judge, you're going to need his court clerk to be on board with you to make this happen. And
Julie, we have another question about whether victims are notified when firearms are returned. And I think this is going to be different from community to community. One of the complicating factors with this is the confidentiality of the petitioner's information, but most places have a way of sealing that file so that the court can access and notify that petitioner that the respondent is getting his guns back. Some places have it where the petitioner just checks a box that, yes, I want to be notified, or I don't want to, but it really is from community to community much different.
And the petitioner would certainly be aware of what the length of their protective order was, and the surrendering of the firearms is only as long as the protective order. So if they don't ask for an extension of their protective order, they would certainly know that they would be entitled to get their guns back, but the actual, return of the firearms, that would be probably something you'd want to talk about and develop in your protocol, how that could happen. So you all work in a very complex system. So both your individual agencies are complex, but the fact that all of your agencies are interdependent on each other, and both independent and interdependent. So if the court orders a protective order, but law enforcement doesn't enforce it, that protective order is really worthless. In the same way, if the court orders firearm surrender, but law enforcement doesn't surrender the firearms, that order is essentially worthless. So you need a dynamic solution that involves all of these agencies that have to be involved. And typically what you need to get started, if you haven't already, is the buy-in of the brass. So bringing together the stakeholders, possibly the elected official from each of these agencies, and getting them to commit to firearm surrender, to being involved, perhaps signing a memorandum of understanding that they will commit staff from their agency to be committed to doing this. Frankly, the elected officials or the brass are not usually the worker bees in this, so they might just be the folks that you bring together for that initial meeting to learn about firearm surrender, to get committed, to make a commitment to their agency participating. And then you probably need a multidisciplinary team, could be your CCR with some additional staff or additional folks on board. But those are your worker bees who are actually going to sit down and hammer out the protocol, and then address the bumps in the road as you go to implement that protocol and try to make it work. When we talk about system change, and that's really what this is, if you implement a firearm surrender protocol in your community as you are changing the system, we really want to think about kind of these three legs of system change. And depending on where you're at in the process, you may need to do different aspects of this. Perhaps you already, and as we know, several of you on the call have already developed a protocol for surrender and you're actively surrendering firearms. So you might be in the process of wanting to jump into this system change circle at the audit, and you want to start auditing files to see if surrender is being ordered when it should, as often as it should, if we're following through and guns are actually being surrendered. So maybe auditing the system to see if the policy that you put in place is working. Maybe others of you are at the point where you have to develop a policy first, and then you need to maybe train on it before you can audit and see how the system is working. You can jump into this at any point, but all three of these are necessary if you're going to make lasting systemic change and not just create a policy that only sticks around for a year or two and then goes away. So you want to think about training. That should be part of your protocol, right? How are we going to train on this? Are we going to do it yearly? We're going to train court staff, law enforcement, prosecutors, anybody who's involved in the system where firearm surrender laws are going to be used. And think about not just training on the protocol, but really the why behind it, the dynamics of domestic violence and guns, and why this is so important. People will comply better if they know why and they believe in it. Your policy We went through all those 6 steps, those things you have to think about, the ordering of the surrender, how the notification and obligations will be communicated, what's going to be your reasonable time frame for surrender. If your time frame is too long, we haven't really achieved our goal of making that very volatile time of leaving a relationship any safer. So what's a reasonable time frame that is going to keep victims safe? There are options for surrender. Is it law enforcement? Is it a federally licensed firearms dealer, or is it a third party? What is the compliance mechanism if they don't follow through, and storage for and return of weapons? And then finally, put in place in your protocol how you're going to do an annual review, whether you do it with internal folks or external, looking at maybe just one department or the whole system, looking to see if the policy that you've written is actually being enforced and used in the way that you wanted it to.
And guarding against backsliding after a length of time, which is always a possibility.
Right. I think we have seen a number of communities, David and I have through the years that we've been doing this work, who get very excited about firearm surrender, but maybe have one particular champion. And when that champion takes a new job, doesn't get reelected, or just generally moves on, we see that protocol, that surrender just fall apart. So really thinking about how you can institutionalize this program and this protocol in a way that isn't dependent on a single individual to keep it moving is really important. So Dave is the director of the National Resource Center on Domestic Violence and Firearms. I am a consultant, but I've been working with Dave for 5 or 6 years now on this. So we are actually available. We are grant funded to help communities do firearm surrender. So we can help you in a variety of ways, answer your questions. We can provide resources. As I said, we have access to forms and protocols and videos that other communities are using that you could model yours after. We can come out and provide training like this webinar, or on different topics, or even have that meeting of the brass to be there to give you the support and the education that they might need to get on board with doing firearm surrender. And we're also just available to provide technical assistance along the way as you hit bumps in the road. And because we are grant funded to do that, that comes to your community at no charge to you. You can reach out for any assistance that you might need in developing your firearm surrender protocol. Did you want to say anything else about that, Dave?
I think you covered it. We're always available, and whether it's you have a small tweak you want to make, or whether you want to look at the whole, set up a whole protocol and whole project, we'll help you with anything you've got questions with, and we're always available. So if you've got questions or comments, please let us know.
Yeah, so finally, we are here to answer your questions. So if you can put them in the chat, that's right in the Zoom webinar. You can go back out to Menti, and if you type in your question there, the same number we've been using all along, 91690907, that will allow your question to show up on the screen for everyone to see. So either way is absolutely fine for us. If anybody has any questions, we can answer.
While we're waiting for those questions to come in, thank you so much, Julie and Dave, for sharing your time and expertise with us. Attendees, you will get the evaluation as well as the recording of this webinar within 24 hours, so keep an eye out for that. Once you complete the evaluation, then you'll receive the link for any accreditation information you may need. And if you'd like to share this webinar with others in your community, since it so often is and should be a group effort, this webinar will be posted on our website, and we can also send you a direct link to that. Julie, have there been any questions come in?
Not on the Menti. I haven't seen any, nor on the chat.
Great. Then we are good to go, and we'll say goodbye to everyone. Thank you again for being here, and I hope you'll have a great rest of your week and weekend.
Thank you.
Thanks, everybody.
Thank you.
Thanks again.